Hello, my name is Beth Norton, and I'll be presenting to you today on the Virginia Healthcare Decisions Act. This presentation is in honor of National Healthcare Decisions Day, which falls each year on April 16th and aims to help people across the U.S. understand the value of advanced healthcare planning. As a quick disclaimer, I'm obligated to inform you that this presentation is not intended to be legal advice. Hancock Daniel is offering this presentation as an educational opportunity to learn more about Virginia's laws covering advance directives. You should contact legal counsel if you have questions when applying the law to the individual facts and circumstances presented by the issue at hand. Now let's jump right into what we're here to discuss. The goal of today's presentation is to provide you with a basic understanding of Virginia law on advance directives, so that you, as healthcare providers, can feel comfortable having these very important and necessary conversations with your patients and their families. Conversations about advanced care planning are much more prevalent today than they were a decade ago, particularly for the elderly population or those suffering with a terminal illness. Recent studies indicate that nearly 70% of older Americans complete an advance directive prior to their death. This is significantly higher than the rates reported a decade ago, which were in the 20 to 30% range. And the great news is that this trend is likely to continue, particularly given last year's monumental change in the advanced care planning landscape. Effective January 1 of last year, Medicare began reimbursing physicians for having advanced care planning discussions with patients and their families. Now that physicians are reimbursed for their time, the hope is that this will encourage more physicians to have these important conversations, allowing patients a better opportunity to have their treatment preferences known and honored. Patient education regarding disease trajectory, prognosis, and the importance of advanced directives is crucial to improve end-of-life care and outcomes, and are conversations that should be had long before patients become too ill to communicate their wishes. While the studies indicate that the utilization of advance directives has increased significantly in the elderly population, it's important to note at the outset that advance directives are useful for people of all ages and current health status. Any of us can be struck by an unfortunate accident or illness at any time in our lives. Why ask your patients to create an advance directive? Better yet, why should each and every one of us create an advance directive? The benefits of advance directives are real. Studies have shown that conversations regarding advanced care planning and advance directives offer many positive outcomes. Conversations regarding advanced care planning increase compliance with patients' wishes and improve quality of life because they make the patient's treatment preferences known. Advance directives allow patients to designate the person they feel is the right person to make their healthcare decisions, rather than relying on a very strict next of kin standard outlined by law. Advance directives also ensure that the patient's healthcare choices are honored by their family and their treatment team. I can't tell you how many times I get asked whether a family member can make treatment decisions that are contrary to what the patient told the treatment team they wanted, but that the patient never put in an advance directive. In addition, an advance directive reduces the burden on the family. Studies have shown that advanced care planning lowers risk of stress, anxiety, and depression in surviving relatives of deceased persons. I don't need to tell you that the decision to withdraw life-sustaining treatment for a loved one often comes with feelings of guilt. It can be much easier when the patient has taken that decision out of their loved one's hands. And finally, advance directives also have the potential to reduce family conflict. Sadly, these situations often bring out the worst in people, and a clear advance directive decreases the opportunity for families to fight over the care of their loved one. For you as a provider, an advance directive also offers the following benefits. It allows you to provide better care to your patients. Having a discussion about advanced care planning opens up the conversation with the patient and provides an opportunity for you to provide more education regarding their diagnosis and the treatment options. It also provides a platform for you to set appropriate expectations and limits on treatment, which improves patient satisfaction and reduces liability. Advance directives also reduce liability for the treatment team. As a provider, you don't have to worry as much about legal liability when you have documentation from the patient demonstrating that they do not want life-sustaining treatment. For those patients who do not want aggressive treatment, it can help improve quality and efficiency of care and lower end-of-life healthcare costs. On the other hand, if it is a patient who wants the most aggressive treatment available, provided it's medically appropriate, then it allows them to say so and to have their wishes honored. Emerging data has shown that advanced care planning reduces end-of-life healthcare costs without increasing mortality. So just a little history on the evolution of advance directives in Virginia. As most of you know, the Virginia Healthcare Decisions Act is the law in Virginia governing advance directives and substitute healthcare decision-making in the absence of an advance directive. This law was enacted in response to the ongoing ethical debate nationwide over end-of-life decisions and withdrawal of life-sustaining treatment from those in a vegetative state or suffering with a terminal condition. In the 1980s and 90s, cases like Terry Chavo and Virginia's own Hugh Finn case highlighted the importance of having an advance directive early in life. As many witnessed through state and national media coverage for over 10 years, both of these patients suffered in a vegetative state while ongoing court battles between family members ensued over whether life-sustaining treatment should be withdrawn. In both of these cases, neither individual had an advance directive. In 1990, Congress passed the Patient Self-Determination Act, incentivizing hospitals, nursing homes, and hospices to implement programs that provide patients with information about their rights under state law regarding healthcare decision-making and advance directives at the time of admission. This act also prohibits institutions from discriminating against patients who refuse to create an advance directive. In 2009 to 2010, substantial comprehensive revisions were made to the Virginia Healthcare Decisions Act. Originally, the law only allowed an advance directive to designate a healthcare agent and specify whether a patient did or did not want life-prolonging treatment should they be diagnosed with a terminal condition and unable to communicate their wishes. Following major changes in the law in 2009, advance directives today not only address end-of-life treatment for those in a terminal condition, but also allow patients to dictate any and all forms of healthcare treatment they do or do not want at any stage of life. Today, an advance directive can specify any and all types of healthcare treatment, including providing instructions regarding medications, surgery, blood transfusions, chemotherapy, radiation therapy, psychiatric treatment, life-prolonging procedures, palliative care, or admission to a particular nursing home, assisted living facility, or other healthcare facility. Before relying on an advance directive or an agent appointed under an advance directive, the law makes clear that the patient must be determined to be incapable of making their own healthcare decisions, and for those suffering with long-term mental incapacity, this determination must be reassessed every 180 days. Today, the Virginia Healthcare Decisions Act also specifies how to handle situations in which the patient objects to treatment, allows a patient to designate an anatomical gift in the event of death, and also allows a patient to authorize their participation in healthcare research. In 2015, our Virginia legislature again reacted to an event that inspired an ethical debate around the country. In 2013, a pregnant woman in Texas suffered an embolism and was declared brain dead. Sadly, she was pregnant, and a legal dispute arose as to whether she was legally dead and thus not in need of life-sustaining treatment. Texas law at the time complicated matters because it prohibited the withdrawal of life-sustaining treatment for pregnant women. Ultimately, in January 2014, the Texas court held that the woman was legally dead and life-sustaining treatment was withdrawn. Virginia law did not have a prohibition similar to the one in Texas, but to provide clarity, Virginia passed legislation in 2015 which allows a woman to specify whether or not she would want life-sustaining treatment administered or withdrawn in the event she is pregnant and suffering from a terminal condition. This directive may be different from what she would want if she is not pregnant. Virginia's Advance Directive Law was again updated in 2016. Effective July 1, 2016, all patients discharged from involuntary mental health treatment must be provided with information on how to complete an advance directive and be provided with a copy of the advance directive form if they have not already executed an advance directive. Additional revisions were made in 2017 to revise the technical requirements of the Healthcare Decisions Act. House Bill 1548 and Senate Bill 1511 expanded the list of providers who may make a capacity determination where the proposed healthcare decision is admission to a healthcare treatment facility for mental health treatment. If the patient has executed a valid advance directive authorizing an agent to consent to such an admission, then the law now permits a capacity determination to be made by the attending physician, a psychiatrist or licensed clinical psychologist, a licensed psychiatric nurse practitioner, a licensed clinical social worker, or a designee of the local community services board. These bills also expanded the list of providers who may attest in writing that the patient had capacity at the time the advance directive was executed, as required when seeking to treat over patient protest. We'll discuss this at greater length in the presentation later. House Bill 1567 requires entities who process Medicaid eligibility applications to disseminate advance directives information to individuals applying for medical assistance, including information about the purpose and benefits of advance directives and how the applicant may make an advance directive. Also enacted in 2017, House Bill 1747 and Senate Bill 1242 established a qualified advance directive facilitator position and established the training program requirements thereof. It also protected providers who assist their clients with completing and executing advance directives from a claim that they are engaged in the unauthorized practice of law. Lastly, in 2017, House Bill 2153 now requires durable DNR orders and other orders regarding life-prolonging procedures executed in accordance with another state's law to be deemed valid and given full effect in Virginia. Now, without further ado, I want to dive into advance directives. This is review for some of you, but just to summarize, advance directives created in Virginia must be made by an adult capable of making an informed decision, will not become operational until the patient has been formally determined to be incapable of making an informed decision, which we will cover in more detail shortly, may provide specific instructions regarding treatment, which formerly was known as a living will, may appoint an agent to make healthcare decisions, which was formerly called a healthcare power of attorney. Advance directives may specify an anatomical gift and may authorize participation in healthcare research. So what are the requirements for creating a valid advance directive? It is simply that the advance directive be signed by the declarant in the presence of two witnesses who also sign the document. The patient must be competent to make their own healthcare decisions, and the witnesses must be 18 years of age or older. In Virginia, the witness may be a spouse, a blood relative, or an employee of the treating healthcare provider. That being said, to avoid the appearance of conflict, it is generally best that the agent not be one of the witnesses if possible. Unlike some states, a notary is not required in Virginia, and the healthcare providers can rely on a copy of an advance directive. While it is best to have a written advance directive, it is possible to create an oral advance directive in Virginia in limited circumstances. In order for an oral advance directive to be valid, the patient must be suffering from a diagnosed terminal condition, and the patient's wishes regarding treatment must have been stated in the presence of the attending physician and two witnesses. While not legally required, we always recommend that the attending physician fully document the conversation with the patient and the patient's wishes in the medical record, and that the two witnesses attest to the oral advance directive by signing this document. For purposes of creating an oral advance directive, a terminal condition is defined as a condition caused by injury, disease, or illness from which, to a reasonable degree of medical probability, a patient cannot recover and the patient's death is imminent, or the patient is in a persistent vegetative state. Interestingly, there is no legal requirement that the advance directive be dated, but it is best practice so that if more than one advance directive has been executed and there is a conflict, those who need to rely on the document know which one is the most current and applicable. By creating a new advance directive that conflicts with an old advance directive, it effectively revokes the conflicting provisions in the old advance directive. Without a date, there is no way to know which provision is the patient's current preference. A date can also be helpful in defending the validity of an advance directive if the patient's capacity at the time of execution is ever challenged. Virginia has adopted a template language for an advance directive. Use of the template statutory language, however, is not required. It is simply suggested language to ensure that the patient has considered the full scope of their right to make healthcare decisions and that all the Virginia statutory requirements are met. Forms that contain the statutory language have been published by the Virginia Hospital and Healthcare Association and are available on the Virginia State Bar website. When assisting patients with the creation of an advance directive, it's important that the patient understands that they can appoint a specific individual to make healthcare decisions for them in the event they are unable to make their own decisions. If you have a patient that wants to keep it very simple and all they want to do is appoint a specific person to make decisions for them, they can do just that. Ideally, they would have had conversations with this person about their beliefs and preferences, and the person would know that they have been designated as the patient's healthcare agent. When choosing a decision maker, patients must choose someone 18 years of age or older. The individual must be accessible by phone, but is not required to live in Virginia. More than one person may be appointed as healthcare agent. However, we caution against this because this creates the opportunity for conflicting decisions, which unresolved could lead to the need for judicial intervention. One of the greatest benefits of an advance directive is avoiding the need for judicial intervention and the associated legal expenses. It's better to appoint a single agent and ask that they consult with others. It's also a good idea to appoint a backup agent in the event the primary agent is unavailable or is no longer willing or able to serve. For example, if the primary agent passes away or loses competency themselves. Patients and healthcare staff are not always clear on who gets to make decisions for the patient in the event of incapacity when they have not executed an advance directive or appointed a healthcare agent. There is a provision within the Virginia Healthcare Decisions Act that dictates who gets to make the decision if an agent has not been specifically appointed. Under the Virginia statute, the following individuals in this order are authorized to make healthcare decisions for a patient who has been declared incapable of making their own healthcare decisions: a guardian, the patient's spouse unless divorce action is pending, an adult child of the patient, a parent of the patient, an adult brother or sister, any other relative in descending order of blood relationship, and in some cases, which we'll discuss in a moment, friend who has exhibited care and concern for the patient. If there is more than one person within the specified class of individuals, the majority rules. For example, if the patient's spouse has predeceased the patient and the adult children are the authorized substitute decision makers, and there are 5 children and 3 agree to withdrawal of life-sustaining treatment and 2 do not, then the majority rules. Obviously, it's best to have a conversation with the entire family to provide education and explain the patient's proposed course of treatment and outcomes and encourage the family to come to a consensus. But this does not always work, and the law provides a remedy for those situations where the conflict remains. We frequently get asked whether proof of the decision maker's relationship is necessary and what should be requested. While Virginia law does not speak to this issue, the Medicare conditions of participations for hospitals and nursing homes provides that the facility is expected to accept the assertion and not request supporting documentation unless more than one person claims to be the appropriate representative or the facility believes the individual is falsely claiming to be the authorized decision maker. As I mentioned earlier, there are some instances in which a non-blood relative or spouse can be designated as the authorized decision maker for a patient who is incapable of making their own decisions. Prior to 2010, the law only allowed blood relatives to make healthcare decisions for others. Now, a friend can be appointed as a patient's substitute healthcare decision maker if there is no one in a higher class available or willing to serve, the friend has exhibited special care and concern for the person, and the friend is familiar with the patient's preferences and values. The facility in which the patient resides must also confirm, through a patient care consulting committee, that the individual is an appropriate decision maker. There are some limitations, however. A qualified friend cannot make decisions involving withholding or withdrawal of life-prolonging procedures, which means they cannot execute a DD&R on behalf of a patient. And the friend cannot be employed by the healthcare provider providing care to the patient or the healthcare facility where care is being provided. In order for healthcare staff to be designated as a person's substitute decision maker, the individual would need to seek authorization from the court through a guardianship proceeding. Whether appointed as an agent under an advance directive or acting as a substitute decision maker under Virginia law because there is no advance directive, there are certain rules that must be followed when making decisions for another. According to the Virginia Healthcare Decisions Act, agents and substitute decision makers are obligated to understand and evaluate the risks and benefits of the available treatment decisions. Based on that information, make a decision about treatment that they know the patient would want and not based on their own beliefs and preferences. And in the event that they are not sure of the decision the patient would make, they are obligated to make decisions in the best interest of the patient. As a practical side note, if you find yourself in a situation where the agent or substitute decision maker is advocating for treatment that the healthcare team knows was not the wish of the patient or does not seem to be in the patient's best interest, it's always best to contact risk management or legal counsel so that you can protect yourself from what appears to be the agent's poor decision making. Advance directive can easily be revoked at any time, either by written cancellation, physical destruction, or oral revocation. Oftentimes, the language of a new advance directive will revoke all previously executed advance directives to ensure clarity and avoid conflicting directives. Anytime a patient revokes an advance directive, he must have the specific intent to revoke it and must be capable of understanding the nature and consequences of the revocation. One note about copies of advance directives. While copies of advance directives are valid in Virginia, they can cause confusion if the advance directive is revoked, but all the copies are not destroyed, or those in possession of the dated advance directive are not made aware of its revocation. An important note is that the Virginia Healthcare Decisions Act includes an immunity provision for providers who were not notified of a revocation. Thus, it's important for patients to inform their healthcare team if they revoke their advance directive and ensure that they have a copy of the most recent advance directive on file to ensure their current wishes are honored. Another important point to understand is that a patient may make a partial revocation of his advance directive. For example, a patient can change their mind regarding the withdrawal of life-sustaining treatment and execute an advance directive that only speaks to this issue. Unless the old advance directive is revoked, any non-conflicting provisions of the original advance directive would remain in effect. Also, if a patient protests the authority of a named agent or any person authorized to make healthcare decisions on their behalf, except for a guardian, The individual protested will no longer have authority to make healthcare decisions on the patient's behalf unless the patient's advance directive explicitly confers continuing authority on his agent over his later protest, which we'll address in a moment. If the patient revokes the authority of the agent appointed in an advance directive to make decisions on his behalf, regardless of whether the patient is thought to have decisional capacity, future decisions are to be made by individuals in order of priority within the statutory list of substitute decision makers. As we've discussed, an advance directive can be used for any and all forms of healthcare treatment, including mental health treatment. You should be aware, however, that there are a few caveats regarding mental health treatment. A patient's agent can only consent to the patient's admission to a mental health facility for up to 10 days and only if the following criteria are met. The patient's advance directive expressly permits admission to a mental health facility. The admitting facility certifies that the patient has a mental illness, is incapable of making an informed decision, and needs treatment, and the admitting facility is willing to admit the patient. We've spent a lot of time talking about how to create an advance directive and the types of authority that can be granted in an advance directive, but it's important to remember that an advance directive has no force and effect. In other words, we should not be relying on the decisions of an agent appointed under an advance directive until the patient has been formally determined to be incapable of making an informed decision. Incapable of making an informed decision is defined in the law as unable to understand the nature, extent, and probable consequences of a proposed healthcare decision, or unable to make a rational evaluation of the risks and benefits of a proposed healthcare decision as compared with the risks and benefits of alternatives to that decision, or unable to communicate such understanding in any way. Poor judgment does not mean that an individual is incapable of making their own decisions. We cannot prevent people from making what we believe to be bad decisions. In addition, communication disorders do not qualify. If the individual can communicate in any other way, such as in writing, sign language, or by some other method of indicating their treatment preferences, then we should not rely on a substitute decision maker. So how do we go about determining and documenting that a patient is incapable of making an informed decision in order to rely on the directives set forth by the patient in their advance directive or the decisions of their agent? The attending physician must certify in the patient's medical record that the patient is incapable of making an informed decision as defined previously, and a second physician or clinical psychologist must concur and also certify this fact in the patient's medical record. There is one exception here, where the patient is clearly incapacitated. The exception states that the second physician or clinical psychologist certification is not required if the patient is unconscious or experiencing a profound impairment of consciousness due to trauma, stroke, or other acute physiological condition. On top of all of that, this formal determination must be recertified every 180 days. That's generally not an issue in the hospital setting, where patients tend not to stay for that length of time, but it is a common issue in the long-term care setting. I want to stop here for a moment because it is common for my firm to become involved in a risk management issue where the facility has been relying on the decisions of an agent and there is no formal certification in the patient's medical record regarding the patient's mental capacity or ability to make their own informed decisions. Until a patient is determined to be incapable in accordance with the Virginia Healthcare Decisions Act, they are presumed capable of making their own decisions. It is particularly important to keep this in mind when dealing with the elderly population. Just because a patient is aged and may have a very opinionated family member does not mean the patient is not of sound mind and able to make their own decisions. Before relying on an advance directive or the decisions of an agent, the law also requires that you provide the patient and their agent with verbal notice that the patient has been determined to be incapable of making their own decisions. For patients who have recovered from an unconscious state, or for those patients with varying degrees of lucidity who may be suffering from early signs of dementia, it is important to note that only one physician is required to make a determination that the patient is again capable of making an informed decision. We spoke previously about the situation where a patient objects to their appointed agent making decisions on their behalf and whether you can continue to rely on the agent despite objection by the patient. Well, the law provides two sets of rules when dealing with patients who have been determined incapable of making their own healthcare decisions. The first set of rules involves the scenario where the patient has executed an advance directive that specifically authorizes treatment over their later protest in the advance directive. In that scenario, a healthcare provider must have documented that the patient had capacity at the time the advance directive was made. And remember from earlier that the list of providers who may make that certification was expanded in 2017 legislation as listed at the bottom of your slide. The decision at issue cannot involve the withdrawal of life-prolonging treatment, and the attending physician must have documented that the treatment is medically appropriate. The second set of rules involves the scenario where the patient has not explicitly provided for treatment over protest in the advance directive. In that situation, treatment may be provided over protest only if the decision does not involve life-prolonging treatment, the decision does not involve admission for mental health treatment, the decision is based on the patient's previously expressed preferences or, if unknown, on the patient's best interest, and the facility's Patient Care Consulting Committee has determined that the treatment is ethically acceptable, or if there is no Patient Care Consulting Committee, then two physicians not involved in the patient's care must document that the treatment is acceptable. We frequently get asked if there is no family or individual available to make decisions on behalf of the patient, can two physicians provide treatment in the patient's best interest? And the answer is no. Some states allow this type of substitute decision-making, but Virginia does not. If there is not a statutorily authorized substitute decision-maker available, and the patient is unable to make their own healthcare decisions, judicial intervention is required. In Virginia, this two-physician standard is limited to the circumstance where an agent is making a decision for the patient over their protest, and the physicians are documenting their concurrence with the authorized substitute decision-maker's decision. While the Federal Patient Self-Determination Act requires all states to permit the utilization of advance directives, the requirements for advance directives vary from state to state. Most states have reciprocity provisions, but whether or not an advance directive will be honored in another state depends on that state's requirements. Virginia recognizes advance directives from other states and will consider an out-of-state advance directive valid as long as it meets Virginia requirements or the requirements of the state where it was executed. There is also a military advance directive for those in active duty who move around frequently. Federal law requires every state to honor a military advance directive when executed in accordance with federal law. A military advance directive must be drafted with the assistance of legal counsel and is limited to addressing only life-prolonging procedures or the designation of a healthcare agent. We recommend that patients provide anyone who may be involved in their healthcare decision-making with information regarding their advance directive, as well as their religious beliefs and treatment preferences, particularly the individual appointed as their agent and their physician or treatment team. We also recommend advising patients to review advance directives at least on an annual basis, and particularly if there are any major changes in the patient's medical condition or wishes. If discussed with their physician during an annual wellness visit, it is considered preventative, and generally the patient's coinsurance and deductible would be waived. Since 2011, Virginia has maintained an advance healthcare directive registry where patients may store an electronic copy of their advance directive at no charge. Virginia's Department of Health recently changed the host of the registry and the link in this slide will take you to that new registry. The old link is no longer active. The registry provides individuals with information on advance directives and allows download of Virginia's template form. Once completed, the individual may upload a scanned copy to the registry or fax a copy. I want to address an issue that comes up frequently, and that is whether healthcare providers are required to provide life-sustaining treatment when it's clear to the physician and other healthcare staff that the treatment would be futile. This is a very challenging question and can only be made based on the individual facts and circumstances of the particular case. What I can tell you here today is what the law says, and the law says that the physician does not have to provide treatment that the physician believes is medically or ethically inappropriate. However, if the physician disagrees with the directives outlined in the patient's advance directive or the decision of the patient's agent, then the physician is required to inform the patient and the patient's designated decision maker of the basis for his disagreement. If conflict remains, the physician must make a reasonable effort to transfer the patient to another physician who is willing to comply with the patient's wishes. Ideally, the conflict would be resolved through a well-documented in-person meeting between the physician, the patient, and the patient's decision maker. But if you find yourself at an impasse, unable to reach an agreement, I would highly recommend that you contact risk management and legal counsel. Until the patient is transferred, the healthcare team must continue to provide any life-sustaining support, such as nutrition, hydration, maintenance medication, requested by the patient or his substitute decision maker. We've focused on Virginia law so far, but I want to briefly address the relevant Medicare conditions of participation and Joint Commission standards as well. Hospitals and nursing homes are required to document upon admission whether the patient has an advance directive. They must also provide information regarding advance directives when requested and provide staff education and community outreach on advance directives. Today's presentation is one way of satisfying this obligation. Several times throughout this presentation, I've mentioned instances that require involvement by the facility's Patient Care Consulting Committee, such as when providing treatment over patient protest or appointing a close friend in lieu of a blood relative as authorized substitute decision maker. A Patient Care Consulting Committee can be a subcommittee of an ethics committee or a standalone committee and must be composed of at least 5 individuals, including the following: at least 1 physician, at least 1 nurse, at least 1 social services representative, at least 1 individual with clinical ethics experience, and at least 2 independent members. It is not often that a facility needs a patient care consulting committee to make these types of decisions, but it's best to be prepared to call this committee when and if the need arises. If the facility does not have a patient care consulting committee or cannot assimilate at least 4 members, a quorum, of the patient care consulting committee, 2 physicians with the following qualifications may serve as a substitute. For protest determinations, 2 physicians not involved in the patient's care or determination of the patient's capacity. For friend determinations, 2 physicians who are not involved in the patient's care, are not employed by the facility, and are not in the same practice as the attending physician. As I mentioned previously, this does not allow the 2 physicians to make decisions for the patient. It's simply a mechanism for approving treatment authorized by a substitute decision maker over protest or appointing a non-blood relative the authority to make decisions on behalf of the patient. As we wrap up, I wanted to make you aware of 2 documents that are similar but yet different from an advance directive. The first is a durable do not resuscitate order. Unlike an advance directive, a durable do not resuscitate order is required to be on a special form. It requires completion by a physician. It only addresses the withholding of cardiopulmonary resuscitation in the event of cardiac or respiratory arrest. And now it enjoys reciprocity in Virginia when executed in and in accordance with another state's laws. DDNRs are governed by their own set of regulations, and we could spend an entire presentation on the requirements regarding DDNRs. What's important for today is that if a patient wishes to have CPR withheld, it is best for the patient to have both an advance directive and a DDNR. There's also a document out there called a POST form, which stands for Physician Orders for Scope of Treatment. Similar to a DDNR, the POST is an order executed by the physician. Similar to an advance directive, the POST can address treatment above and beyond simply withholding CPR. This too is an entire presentation on its own, and I would encourage you to seek more information regarding POST in Virginia and the benefits of its utilization in the advanced care planning conversation. Finally, as we end today's presentation, I wanted to close with a few key takeaways for you as providers. First, make sure you have a good process for documenting whether a patient has an advance directive and that it's easily identifiable in the medical record. If a patient states that they have an advance directive, but they don't bring it with them, it's best to ask them to create a new one so that it can be immediately scanned into the medical record. Before relying on an advance directive, be sure to read it and make sure it meets the regulatory requirements, which are that it be signed by the patient and two witnesses. Oftentimes, a financial power of attorney will be mistaken for a healthcare power of attorney, so make sure you read the document and ensure that it addresses healthcare decision-making. An agent appointed under a financial power of attorney does not have healthcare decision-making authority. Finally, before relying on a document or an agent, make sure the patient has been formally determined to be incapable of making his or her own decisions, and that this is documented in the patient's medical record. Here are a few resources that you may want to visit to learn more about advance directives in Virginia or nationally, including the Virginia State Bar website, which contains the Advance Directive form and the Virginia Advance Directive Registry site. I want to thank you for your time today. I hope you learned something new about the advanced care planning process and advance directives in Virginia, and that this presentation encourages you to consider completing an advance directive or revisiting your existing advance directive to ensure it reflects your wishes. Thank you.